next session brings more of an angle of jurisprudence, law, and policy making. So I'd like to invite the panel to come up on stage, please. The first panelist we have is Mr. Matthew Chaco, partner at Spice Route Legal, and the man responsible for heading the technology, media, and telecoms and data practice groups of the firm. He tinkers with tech in his spare time and comes with the disrepute of having hacked a website for the first time in '98 and gamed Yahoo search for the first time in '99. So I'm sure there's not too many of our speakers at this conference who have hacked websites before, but Matthew, it's great to have you here. He has over 22 years of experience in assisting some of the largest players in financial services with devising simple legal strategies for complex legal, regulatory, tech, and data concerns. So please welcome Mr. Matthew Chaco of Spice Route Legal. Round of applause, please. Thank you. Welcome, Matthew. Secondly, we have Mr. Chanchal Sarkar, advisor in the Ministry of Finance, Government of India. In addition to looking after financial stability, cybersecurity, and G20-related issues, Mr. Sarkar is also co-chair of the G20 Global Partnership for Financial Inclusion Working Group. Prior to these assignments, he's had a long and distinguished government career spanning over 25 years, including postings in various government departments at multiple leadership roles. Welcome, Mr. Sarkar. Thank you. Next up, we have we have Ms. Neha Chaudhary, partner at Ikigai Law, a technology-focused law and policy firm, where she heads Ikigai's tech advisory and public policy practice. Per the Legal 500, she's one of India's best data protection lawyers, ranked leading individual for several consecutive years, and is recognized for her TMT and aviation work as well. Please welcome to the stage Neha Chaudhary. Thank you very much for being here. And lastly, we have Mr. Rahul Mathan, who's a partner with Tri-Legal Law and leads the technology practice of the firm. After a career spent advising clients on issues as diverse as cryptocurrency, telecoms, regulation, internet and social media law, and technology M&A, he's played an increasingly active role in helping shape technology policy in the country. Rahul writes a weekly column on the intersection between tech, society, and the law. His latest book, The Third Way, India's Revolutionary Approach to Data Governance, describes how digital public infrastructure could offer a new approach to data governance. He's also served on the RBI Committee for Household Finance and the Chris Gopalakrishnan Committee on Non-Personal Data. Please welcome Mr. Rahul Mathan. Moderating the discussion amongst these heavyweights is Mr. Venkatesh Hariharan, the India representative at the Open Invention Network, an organization that protects the free and open source software community from patent litigation. Venkatesh has several years of experience in journalism and public policy, and is involved in key policy issues like open source in government, open standards, software patents, Indian language computing, free speech on the internet, and privacy. He's also served as director of fintech for iSpirit and set up the Omidyar-funded data governance network at IDFC Institute. So thank you for being here, and Venkatesh, over to you. Thank you.
Good evening, everybody. How many of you were there at the opening address by Mr. K.V. Kamath? I think it was really stunning to hear him talk about the fact that we are at a new super cycle in finance. And coming from somebody like Mr. Kamath, who's been a legendary banker and a big picture thinker, I think this is really a massive endorsement of the work that India has done to build digital public infrastructure. So without much ado, we'll dive right into the panel. Today we have three of the leading privacy and data protection lawyers in India. We also have Mr. Chanchal Sarkar, who's got a very unique perspective as one of the few individuals who are leading the DPI globalization efforts as part of the government of India. And today's topic is fairly complex. We'll try to unpack it. The reason data protection and privacy is very complex is because you have to balance the interest of consumers and you have to balance the interest of industry, ensure that the data protection norms are not too onerous, too difficult for industry to comply. At the same time, you have to protect the consumers. And the task of striking a fine balance between the two is that of the government. So let me come quickly to Rahul. In one of our earlier conversations, you spoke to the data governance network, and you made a comment which has stayed with me till date. You said that consent has become a get out of jail free card, and we all experience that because none of us have really probably read a consent notice unless you're a lawyer. So do you still hold that view 4 years down the line, and or have things changed?
So when I'm asked this question, I usually play a cheap little trick. I tell the audience, ask a question to the audience. I'm going to do it now, realizing that it's at considerable risk that I will have egg on my face. The question is, how many of you have read all the privacy policies on all the apps on your phone? Please raise your hand. Oh, phew. I thought, at least in this audience, which is like, all about digital consent, that you would realize the importance of doing it. But this is the fact. Yeah. And I'm sure you all have at least more than 20 apps on your phone. And so you cannot be using your apps without saying, I agree. That's just the nature of the way the apps work. And so you have agreed to things. And there's documented evidence that a very famous company, and I won't tell you the name of the company, has hidden within its privacy policy a commitment to sacrifice their firstborn on the 7th full moon of the year or something like that. And you've agreed to it. Now, if that is the case, why do companies keep these privacy policies and get you to consent to them? Because if something happens, they can actually say, look, but you agreed. Yeah. And that's why I say it's a get out of jail free card. But I have, to answer your question, sort of changed my view from what it was. It was probably longer than 4 years ago, because we've had COVID in the middle, and you just forget, like 3 years vanished because of COVID. But the fact is that the account aggregator system has made a slight difference to the way in which we think about consent. And when I spoke at the Data Governance Network, I would argue that it was perhaps at the very, very early stages of account aggregator or before that. And at that point in time, we didn't have the opportunity that the account aggregator system gives us. And so we used to front load all our obligations for consent in the privacy policy itself, because we didn't have the opportunity to come back and ask you again for portability consent. And so I have formulated a sort of an evolution of that thinking, which is that the account aggregator system has allowed us to split consent into two types of consent. First is collection consent. When you sign up to a service, you give them the service the ability to, the permission to collect certain amounts of data, and that I call collection consent. And in the old system, you also had to give them the consent to transfer that data to someone else, because there was no chance you would come back. But the account aggregator system allows you to do consent to port at a later point in time. That, I believe, and I don't think, even though we're at 8 billion loans a month and crazy number, 8,000 crores worth of loans, a billion loans a month. I don't think we're at the point where we can really see this distinction between collection consent and consent to port actually come to be. But if I was to look to the future, I think that the account aggregator system has allowed us to start to reshape the thinking around consent, to split consent into these two ways. And if that is the case, then my answer to your question would be a bit more nuanced, that it's not so much a get out of jail free card, it is a little more autonomy. It does give people a little more ability to control what needs to be done with their data.
I think the other advantage with account aggregator is the dashboards where you can see what consents you're given, the ability to revoke those consents, etc. And if time permits, we can talk a little bit more about that. Matthew, I want to come to you. And one of the interesting things about the DPDP Act is that I think it's one of the few acts anywhere, or probably the only act anywhere in the world, that has enshrined the role of a consent manager. And kind of reminds me of the old days where you had assisted interventions and people the public call offices, etc. So So explain the significance of the consent manager for industry as well as for consumers. How does it help the industry and consumers?
Right. Leading on from something that Rahul alluded to and was obvious from the fact that none of you raised your hands, is the fact that there are problems with the idea that consent is at the heart of privacy and data protection. Regardless, we've made and Europe obviously, believe it or not, in 2016 and 2017, before the GDPR, all the European experts were saying we'll have to take consent for everything. But Europe's moved away from that and has got something called a legitimate interest. When I was first asked to comment on multiple drafts of this data protection law, my biggest point was, let's get legitimate interest in. The government's taken a policy decision, appears to have, if it's not further watered in the next few days, that consent will be the center around which our data protection and privacy law remain. Given that most of us give consent without reading it and don't know how to take back consent and how to manage this entire process, the government is, and I thought, absolutely fabulously come up with a structure of a consent manager. No doubt inspired by the account aggregator framework, right? But don't think of a consent manager as an account aggregator for all data. Think of the account aggregator as the prequel to a consent manager. Right now, this consent manager will help individuals manage their consent. Give it, take it back, delete it, change it, modify it, all of that. As it goes on, further duties may be imposed on the consent manager, which might make it, so consent manager part 2, part 3, part 4 might actually be the most effective, albeit state-centric, tool to manage your consent properly. And on the other side, to go back to the Europe story, if you look at the new legislation from Europe on, let's say, artificial intelligence, on digital markets, etc., they've come back to the general idea of consent. I think so. Consensus now indicates that there has to be consent, so we need to use it. And I think this could be something that could actually be very useful globally, sir. For example, for us to say, hey, we know there are problems with consent, and one of our solutions is a registered licensed consent manager whose job may well be to monitor consent also, to make sure that once I give consent, the person who's got my data does not misuse it. And maybe at a later date, make claims before the data protection board on behalf of many, many customers whose data has been misused. So this consent manager ecosystem is very exciting. I think in all the DPDP Act proposals, it's actually the one part of it that excites me, particularly when seen with the lived experiences of the account aggregator framework.
Okay.
But we'll have to see.
Yeah.
We're at very early stages.
Thanks. You know, it reminds me, NIPFP did a study where they actually asked a bunch of law students, to read the privacy policies, and they found that the comprehension levels, even though these are like in the students from the top law schools in India, they had a hard time reading and understanding the consent notices. So I think we have a huge way to go, and if the consent manager is implemented well, that could be a solution to this problem. Neha, let me come to you. You know, you work with organizations that are implementing their data protection rules, etc. How difficult, how challenging is this journey? And, especially, I think the larger organizations will be able to implement data protection norms, etc. But what about the smaller organizations? And before that, let me just maybe do a quick check, In how many of your organizations have started and embarked upon the journey of complying with the Digital Data Protection Act, the DPDP? So about half of the room.
6 people, 7.
No, 8. Okay.
1, 2, 3, 4.
I see people putting up their hand and then putting it down. So there is some ambiguity.
There's no data protection regulator here, so you
No,
can...
yeah. So yeah, over to you, Neha. How easy or how difficult is it? And are there any guidelines for those who are yet to start?
Yeah, sure. Is this working? It is, right? Okay. Yeah, so look, I mean, when we're advising clients, we're getting them in all shapes and sizes. Obviously, some of the larger companies who are working in markets around the world, I feel like are in a little bit more advanced stage of compliance, because you're already complying with 20 laws around the world or 80 laws around the world. This is sort of one more, right? But I'll put a caveat to that, because very often we also get this question, oh, I'm anyway GDPR compliant. Does that mean I'm already compliant with India's data protection law? And the short answer to that is no, right? So in terms of approach, in terms of best practices, typically we advise clients to think about this in three parts. One, just figure out where you are today, right? And that means getting a true, honest, like just super bare bones perspective of what are the various data points that you're collecting, figuring out what the journey is within the organization, not doing this at a top level exercise. Very often, and I'm sure other lawyers on this panel will also have that experience, very often we end up being on calls, and I feel like we're mediating this conversation between the product team, the marketing team, the legal team, the compliance team. It's like that's the first time they're having this conversation among each other and asking these questions about what are the various data points that I'm collecting, and what is the life cycle within the organization, right? And I think that that's absolutely critical to be able to get down to super granular detail. It's not enough to have top level answers that say, I'm collecting this data because tomorrow I want to use it for marketing. What does that mean, right? Like, what exactly are the data points? Where is it going to go? Is it going to go from A to B to C to D? How many people within the organization are going to have access to it? What are the various data points? So you need to know exactly where you are, and you need to know where you are in great detail. That's one. Second is this gap assessment of where where am I today and where is it that I need to be? And this honestly depends on a whole bunch of different factors, right? It depends on whether you think that you are a data fiduciary or a data controller, whether you're a data processor who is not actually making decisions about the hows and whys of the data. You're only just following the actions or the instructions of a data controller or a data fiduciary. But again, here also, it's not a blanket answer. It's a very use-specific, data point-specific answer. A very simple example that we give is, insofar as employees are concerned, at the very least, you will be a data controller or a data fiduciary because you're making decisions about substantive decisions, right? But in other aspects, you could be a vendor, you could be just some market analytics company, and very often, in the account aggregator ecosystem, you may or may not be a data fiduciary. You may also be a data processor. But so I think just understanding where we need to be is a function of what kind of role we're playing, what are the markets that we're operating in, what are the geographies that we're operating in. The way that the Indian law is designed, it leaves the door open, and we already have a lot of sector-specific obligations that govern data protection and data compliance, and that's going to continue to be the case, right? So just having an awareness of that as well. It's not just about the DPDPA, it's about the DPDPA+++. And the third stage is really, okay, now how do I I figured out where I am, I figured out where I need to be, and then the third stage is about getting there, right? And I think the previous panel also did touch upon some of these things. It's your external facing, it's your privacy policies, it's your training your employees, it's getting your tech architecture in order, so on and so forth. The mistake that I think very often we encounter from clients is that they want to start from level 3, right? You fix my privacy policy and that means that I'm DPDPA compliant, but it doesn't work like that. Like, how do I fix something like this for you? It's just sure, I can make the changes to that draft and give it to you, and I can fix your vendor contracts for you, but that's not really sort of achieving any meaningful compliance.
So who's been your best client and who's been your worst, and why?
So
Without naming names.
So I think the best ones are obviously where they come up with like super interesting questions, right? Where you have to think about whether, which way the law applies. And I really enjoy the fiduciary processor questions, but I think very many people on my team will not necessarily agree with that. But I think the worst ones, I would say, are exactly what I was saying before, right? It's just a sort of checkbox, spot check exercise. I just want to do this. I just want you to sign off on my privacy policy. I just want to sign off. I just want you to do this on like basic top level changes. I don't think that's meaningful. And yeah, maybe that's why I would say those are the worst.
Yeah, I think Venki was definitely aiming for a name, although he pretended like he wasn't.
I will keep quiet now. And,
Chanchalji, I want to come to you. I think India's G20 presidency was quite remarkable because one of the 4 big themes of the presidency was digital public infrastructure. To me, what is interesting is, as somebody who's been in the industry for 30 years, this is the first time that there is an Indian idea that is going global in the tech industry. I mean, we've always seen social media, for example, being imported, search engines being invented outside India, coming to, and then we use that. But here is a homegrown idea that is seeing traction globally. So post the G20, what has been the progress, and particularly specifically around DEPA and the account aggregator, what is the uptake, what is the interest, what is the traction that you're seeing from countries around the world?
Yeah, thank you very much for this question. As I said, like there are, if I understood your question correctly, you're asking that the post G20, what is the progress? See, there are 2-3 levels. One, that narratives, building the narratives. So as I said in the morning, briefly about like when we started this very concept of DPI, in January 2023, everybody asked, what is DPI? Because there is a digital public good and all those. So what is that we were talking about? So then we kept on explaining. We wanted to showcase, we showcased. And in January it was this, and then March again they asked, oh, okay. So now we to see that then March it was like, somewhat okay, since you were saying, though we understand. And then came July, and then July it was kind of confident, okay, oh yeah, there is a story. Okay, we can hear that. And then kind of some sort of very reluctant agreement. And at the same September it was endorsement and unanimous. So there is a huge thing in terms of narratives that is going on even today, because and also in the G20, that working group particular, this works for 3 years document called Financial Inclusion Action Plan, where we embedded. Rahul would say that the digital DPI is like techno-legal. If you agree, then you agree lot of legal elements. So therefore, you don't need to, you don't have additional burden of thinking of regulatory compliance. Similarly, FIAP is a DPI. So FIAP, we had included the DPI, Digital Public Infrastructure, and that yesterday, the one out of the 3 deliverables, the 2 of them had quite a significant amount of DPI, and it was unanimously again endorsed yesterday in Rio. So therefore, there are going on things which are developed here, and it is going on. In fact, after that, you know that Pramod was saying that it takes 5-6 years, even after having agreed also. Yeah. So therefore, it takes a lot of time. Like there are every day new interests. I mean, not in a regular interval, we are getting interest from various countries. In fact, there are a lot of, even Brazil had interest. Even South African delegates are coming visiting next week, December. So therefore, a lot of such engagement, and we also are engaged bilaterally and beyond G20. So there is a good amount of interest.
I think the good thing is that after India's presidency, the follow-on is from Brazil and then from South Africa. And I think both Brazil and South Africa are quite interested in taking the DPI discussions forward. So it's not just a one-time, one-off thing which kind of fades away after India's presidency, but something that continues and has a life of its own after post India's presidency. I think the other thing is, I think our Prime Minister is extremely tech savvy, and he has also spoken a number of times about digital public infrastructure. Oh, yes. So, Rahul, a burning question, I mean, all of us are very familiar with the fact that, today we get about 3 spam calls every day. The kind of digital arrest scams, etc., that are happening. In fact, just today as I was having lunch, I had somebody call me and say, hey, I got this call. I was on Skype for the last 3 hours, and people asked for my Aadhaar, OTP, this, that, etc., etc. And will I be arrested? So I had to. Can the infrastructure that we are building out, help in? I mean, one of the reasons that this is happening is because phone numbers are leaking all left, right, and center. You go to a grocery store, you're asked for your phone number. You go to a shoe store, you're asked for your phone number. You don't know who's, your courier is getting the phone numbers. But do you see the DPDP Act as helping curb some of this misuse?
I mean, I hope it does, seriously.
Absolutely.
But I, once again, since I'm clearly making this an interactive session, all of you who raised your hands to say that you are now working on compliance, have you had this conversation with your sales teams? Because I tell you, your sales teams today know no way to work. Their entire mode of operation and functioning is based on buying databases of customers that they can call. And I tell you this, DPDP does not allow that. Yeah. So the entire sales function, as I know it, to all the organizations that I've gone to talk to them about DPDP, the people who push back the most are the sales teams who say, I don't know how to work. I mean, what do you mean I can't buy data? I don't know if they've got, but clearly they assure me they've got consent, and so that should be okay. But if I don't buy those databases, how will I sell? Now, where are they buying their databases from? This gets to the point of, if legitimate companies, and these are the biggest banks, all represented in this conference, I get calls from all these people saying they're from these big banks. If they are doing it, can you imagine how many fraudsters are also capable of doing it? Because as you see, the ROI on these frauds is extremely high. It goes into the crores. So to spend a little bit of money to buy a database that all the big banks are buying and using as part of their real business model, it's a reasonably good ROI for them to do. The question really is, will DPDP actually prevent that? That's all going to depend on enforcement. And we were having a discussion as we were sort of preparing for this. I thought, DPDP will come in, and maybe the day before DPDP comes into force, all my clients will wake up and say, oh, I have to sort it out. But, I think Matthew was a little more pessimistic, and he said, we'll wait till the first fine happens. Because when the first fine happens, then certainly people will wake up and say, I could be the next fine. But quite frankly, the act has been enacted 1 year ago, September last year. Yeah. We should not be asking the question, are we starting now? The act is in force. All that we are waiting for is the rules, which are not going to change anything in the act. It is subordinate legislation. It's going to provide some sub-legislative clarification, but the act is the act. You all have to comply. All your sales teams have got to delete those databases and find new ways to sell. But none of you are doing it. Can I ask one last question? How many of you have instructed your sales teams not to do this?
No hands. So yeah, I guess to paraphrase what Rahul is saying, start your data protection journey right away. Don't waste a single minute. Matthew, I think I feel that now I'm turning to you for every new term, and another new term that the DPDP Act brought into force was the term data fiduciary. And we understand data fiduciary as, for example, if you give me your data, I have a fiduciary responsibility to use that data in your best interest. We don't see that, for example, there's an experiment that I had done earlier, a friend of mine and I, we were both leaving IIT Bombay back to Bandra on Uber, and I had set Bandra as my home, and he hadn't. And he got a lower rate than me. So the fact that they knew that, Bandra is my home, and they were able to use that to extract a higher price for me. So clearly that's the, opposite of what a data fiduciary should be doing. But what do you think will be the long-term implications of this term? Because once it is there, courts also will start using that term to interpret what has been done with my data.
Yeah, so Venki, you've gone from my favorite two words, consent manager, to my least favorite two words, which is data fiduciary. Now, data laws all over the world are grappling with, let's use the word controller, what data controllers' duties they have to data subjects, right? About a decade or so ago, New York came up with the term data fiduciary. So there's one law which predates it. Yeah, New York. Okay. But everyone was so scared by it that that law is dead in the water. Right? So that law doesn't exist. I'm guessing, from whatever limited knowledge I have of the legislative process that this went through, that the word fiduciary was used as a hope, right? It wasn't, in my view, meant to be fiduciary as the law otherwise might know it. In fact, I've had at least 100 clients over the last 1 year call, international clients call and say, do we have a duty of trust? In my view, as the legislation now stands, there is no duty of trust. But whenever I mention this at the Karnataka High Court, every litigator turns around and says, "Nee, it's a fiduciary. Yeah. It's a duty of trust." Someone is going to argue this in court. And some judge who may not have this legislative history and background and all of that is going to say that there is a duty of trust that everybody who collects your data has. The moment that happens, that means everything you do with that data has to be in the interest of the person who gave that data. In fact, you can't do anything else. Your hands are tied. That will make this law unworkable.
Why do you say it will be unworkable?
Because the transactional cost of evaluating every processing activity on one of the highest pedestals known to law will mean that every company will double check everything they do with that data to the best in class standards of protection, right? And that is something which, to my mind, from my glimpse of whatever companies are doing in every other country in the world, is a very high threshold. Aspirationally, maybe a good thought.
So, as a consumer, I would like, the data controllers to treat my data as a fiduciary responsibility. So, I like that term from that perspective. But I understand the realistic challenges. But
yeah, but just given the question, I'm curious to see Rahul's and Neha's response to the same question. And maybe not on the practical bits, but on the theoretical. Do you think that a controller is a trustee of the data? Morally.
So can I say that I think I slightly disagree with you on the intent. I think the intended for it to be, I think that term was used very intentionally, at least in the earlier iterations, right? Like
the Justice Sri Krishna.
The Justice Sri Krishna, the entire process, right? So for folks that may or may not have followed this, but the genesis of this recent, the recent history of this is we had a right to privacy judgment. The Supreme Court recognized that we have a fundamental right to privacy. Union Minister at the time, IT Minister, committed to the Supreme Court that, hey, we're working on a data protection law that's going to protect privacy, and we set up the Justice Sri Krishna Committee report. And there I think they talk a little bit about how they arrived at this, right? And they spend a lot of time talking about we intend for this duty of trust to be there, and we're using this term very intentionally and talking about it being like, it was used with, I think, some amount of thinking, and it was fairly intentional, the use of that term, and it was precisely this duty that he's worried about, that they wanted. And I forget which version it was, but I think it was the first draft that the Sri Krishna Committee had released, had this blanket obligation which was sort of do no harm, right? There was a blanket, the first duty of, or the first obligation
Do no harm.
was essentially something like, a data fiduciary will ensure that it is acting in the interests of a data principal at all times, or something like that. I'm paraphrasing a little bit, but it was literally the first thing, and then everything followed from there. Your purpose, specification, minimization, all of it followed from this one thing that basically said do no harm. That's changed in the version that we have now, but it's entirely possible that, this is where like the anxiety may not be unfounded, basically. But
Rahul, do you want to add to that?
Yeah, just very briefly. I mean, I think trust is a very high bar, but I don't, for this audience, necessarily want to get into jurisprudential technicalities. Directionally, though, I think that's the direction that we should be going. I think the world, forgive me, all you people who make your money out of data, has moved too far in the direction of data exploitation. And I think even if it's not the way in which it is actually written in all the other provisions of the law, directionally that is the direction that this law wants to take it. To say that the exploitation of data must stop. And directionally, we must think of ourselves as trustees of data. Now, the reason why Matthew is right in saying that this cannot, the law may be unworkable because of this is because a trustee, as you know, are people who manage your financial affairs and things like that. That's a very, very high threshold. And to have, in a world where we bleed data and every organization collects and uses our data, to have everyone at that standard is perhaps unworkable. But directionally, we've got to move away from the world that we currently have, where people say, I spent the money to collect the data so I can do whatever I want with the data. That's not okay. And I think the reason why it's hopeful in this context is because the account aggregator is a technical framework that sort of readjusts this a bit. It says that you've collected the data, it's in your data silo, but I can now pull it out of the data silo and send it to someone else. And directionally, that is, I think, the way in which we can find a middle ground between these two extremes. And that middle ground with the control, that's within the control of the data principal. There's a lot to be done still. My article in the Mint tomorrow is about how we've addressed in account aggregator all the privacy principles: notice and consent, data minimization, data retention. The one that we have not in the current account aggregator framework is use limitation. Once I have got the data, what's to prevent me from using it for any of the purposes not listed? And using one of the papers written by Silence Lab and Sid and a few others, I argue for a multi-party computational privacy-enhancing technology-based solution for use limitation. So that's it's already on the online edition, but it's in the Mint in print tomorrow. Sorry, I'm just plugging myself morning to evening.
You plugged your book in the morning. But yeah, the use limitation is an important thing. I think I was talking to a lawyer who is part of a group which has 14 different businesses. So he was wondering, how do I do the use limitation? So yeah, Chanchalji, you have the last word today. Since you've been part of these global discussions, Neha mentioned that people are already implementing the GDPR, etc., etc. So now you have multiple data protection laws around the world, we also need some kind of standardization of data protection laws so that it becomes easier for companies and organizations to implement that. So are there any global discussions around that, and is India leading some of those discussions?
Thank you. I was hoping that since it's raid that you will not ask me the question. Also, one more reason that I am not a lawyer. Anyway, so since you have asked this question, yes, in fact, if you broadly, this data approach is one is consumer-centric, another is framework-centric, which was the institutional. So there has to be some kind of balance and marriage, or has to be something. While the ultimate objective is to the security and the seamless and the protection. So therefore, there are approaches, as you said, the GDPR, and then even Brazil's own this law. So these are already there. In fact, while developing our DPDP Act, so we have considered all these kind of existing requirements. What are those? And also, if you see our DPDP Act, that has provision for global data exchange, which is also the need of the other approach of data globally. Only the sensitive data would be here. And also there is the concept of kind of the sectoral approach, where the sectoral rules and will be overruling the existing one. So therefore, like, keeping all this into account, data is a very important one, and global discussions are really on, and India has an approach which is the consumer centricity. Consumers should be the focal point, and that's how we are advocating in every forum. And there are a lot of traction of this also. So therefore, I'm quite hopeful.
Is a global consensus emerging that we need standardized data protection laws, or standardized methods of at least some
So yeah, if I say that there is one, then it's not correct. So there are, as I said, their approach and this approach is quite, at variance, while the ultimate objective is the same. But then we need to explain why how it is important, and how this can be scalable, how your objective can be also fulfilled through this. So that's how it's going on. I'm quite hopeful that some kind of solution will come up. Yeah.
Thank you. Thank you, my fellow panelists, for being a wonderful panel, and thank you to the audience for being so patient and giving us a good hearing. Thank you.
Huge round of applause, please, for our speakers. I don't know about all of you in the audience. Please remain on stage for a second as we give you some gifts as a token of our appreciation. I don't know about all of you in the audience, but that was probably the best session on data protection I've heard. Specific and eloquent, yet also lucid and relatable. So I enjoyed it a lot, and thank you all for being here. So thank you for the great talk. Thank you, everyone. One more round of applause, please, for our speakers and for our very skillful moderator, Mr. Venkatesh.